Thank you for participating in the Texas Juvenile Justice Department's e-learning course. My name is Jessica Ford, and I will be narrating today's training on understanding professional liability. Before we begin, please ensure you have downloaded the participant guide. This e-learning course is provided as an alternative to a live training presentation. The Texas Juvenile Justice Training Academy does not guarantee that this option is in any way more or less suitable to prepare the trainee for the performance of their job duties. It is the sole responsibility of the employer to ensure the trainees are adequately prepared for the TJJD certification exam. Scenarios may be included, however, activities have been removed when interaction or engagement with others would be required. Scenarios, if used, are to evaluate comprehension of the material by the trainee and not intended to provide examples from the certification exam. Upon completion of viewing this e-learning course, the employer is responsible for completing all necessary documentation that the training on this mandatory topic was completed by the trainee. No certificate will be generated after viewing this e-course. The material covered during this course is for informational purposes only and must not be considered legal advice. You should contact your supervisor, local county prosecutor, or a private attorney for questions about specific legal matters. For technical assistance and resource information, you may contact the Texas Juvenile Justice Department's Legal Help Desk at 512-490-7121. To begin, let's take a moment to listen to a few statements and watch a video. Statement 1. In 2009, a federal court of appeals upheld a jury's verdict to award an inmate $75,000 in compensatory damages and $125,000 in punitive damages on his claim that a correctional officer attacked him without justification for the purpose of maliciously doing him harm. The court found that both the compensatory and punitive damage awards were justified by the evidence. Statement 2. In 2007, a juvenile formerly detained at the Texas Youth Commission, now known as Texas Juvenile Justice Department, or TJJD, reached a financial settlement with the agency for an undisclosed amount. The juvenile, who was serving a 2-year commitment, was beaten by 4 other juveniles while juvenile correctional officers, or JCOs, assigned to his housing unit were not at their station. The juvenile alleged the officers allowed the assault, which sent him to the emergency room, because they didn't like him. The officers were fired for neglect. It may be difficult to imagine these situations happening to you, but dealing with legal issues is an eye-opening part of being a juvenile justice professional. A supervision or probation officer has several responsibilities which must be performed while on duty. You must follow all rules, policies, and procedures, and if you don't, you can possibly be subjected to legal consequences. During the course today, we will review some of the most common liabilities juvenile justice professionals may face, discuss the criminal, civil, and disciplinary consequences of those liabilities, and explore some ways in which you can avoid these legal issues. This course is designed to establish a foundational understanding of job-related legal liabilities, consequences, and protections. Here are the objectives for today. First, we will summarize the common liability areas that may lead to undesired legal consequences. Second, we will explain the differences between criminal, civil, and administrative consequences. And finally, we will outline the legal protections available for juvenile justice professionals. We will now begin to discuss legal liabilities. Being legally liable means being responsible for your own acts or failures to act under the law. In other words, your official job duties may make you vulnerable to legal proceedings or lawsuits if you act improperly or fail to act as defined by federal, state, and agency laws and policies. Let's turn our discussion to who is at risk when working in a juvenile justice setting. Personal liability. A lawsuit may be brought against anyone who has a connection with the case. At some point in your career, you may be sued personally. If this occurs, someone is claiming you had some kind of personal responsibility or liability while working as a juvenile justice professional. If the case is not found in your favor, you may end up doing jail time for a crime, paying money directly from your own pocket if there is no government insurance or reimbursement, or lose your job. Bystander liability. When an event occurs, there are often witnesses or bystanders. While on the job, if you are a witness to an act or failure to act and you do not report it, you may be held liable in a criminal case or named in a civil lawsuit. As an officer, federal law indicates you may be held responsible as a bystander if any of the following apply to you. If you know a fellow officer is violating an individual's constitutional rights, or if you have reasonable opportunity to prevent harm and choose not to act. Keeping the inappropriate behavior of a fellow officer a secret does not benefit them or you. To truly have your coworkers' backs, you must be willing to report them if they are in violation of federal or state laws or department policies. You may prevent the smaller acts they commit from turning into more significant acts, which may land both of you in a courtroom for criminal, civil, and/or administrative proceedings. Your acts, failures to act, and the acts of your coworkers do not affect just you personally. They may leave others at risk as well, including your supervisor, department, facility, county, or TJJD. Let's talk about vicarious liability now. Vicarious liability occurs when those in a managing role, such as a supervisor or department, are held liable for the actions of the employees they oversee. Supervisors may be held responsible or liable for the actions of employees under their supervision. A supervisor is liable for the acts of other employees when he or she specifically authorizes the act, typically authorizes acts of the same nature as the one in question, or knew of the act but did nothing to stop it from occurring. When an employee acts improperly or fails to act when they should, their supervisor may have neglected to provide all of the information necessary to perform the job. There are 7 common areas of supervisory neglect, including negligent training or failing to train as required, failure to direct, such as failing to explain the limits of a job, negligent hiring, or failing to conduct proper background checks, negligent supervision, for example, failing to correct known mistakes, negligent assignment, such as allowing a staff member with a reckless driving record to continue to transport juveniles, negligent entrustment, for example, authorizing untrained staff members to use de-escalation techniques requiring mandatory training, negligent discipline, for example, failing to take corrective action when inappropriate or unauthorized behavior is demonstrated. Supervisors may be sued for any of these failures and acts of negligence. Lawsuits may also be filed against a department, county, or facility, as well as individuals working within them, when it has been claimed the department, county, or facility directly or indirectly played a role in an employee's conduct or action. These parties may also be named in a lawsuit under the deep pockets theory, or the idea the department, county, or individuals connected with them have more money to pay large damages than an individual. Those that may be sued vicariously for employee actions may include supervisors, managers or directors, and chief juvenile probation officers or facility administrator. Juvenile probation or supervision officers may be included in a lawsuit, though they are often just one name among many. Although anyone can be named in a lawsuit, state law determines the actual person responsible for paying particular dollar amounts. Liability may fall on you, a bystander, a supervisor, department, or facility. So now we will take a moment to determine how you might know if you're liable. Anytime an act occurs while you're at work and you begin to question your liability, consider the following 3 questions in regard to your official responsibilities or legal liabilities. Did the act happen during my scheduled work hours? Was I responsible for setting, enforcing, or following policy? Did I fail to act or ignore information presented to me? The answer to these questions may help in determining if you are liable and whether you should prepare for possible legal proceedings. Let's talk about the most common liabilities which often cause legal issues for juvenile justice professionals. When you were hired as a juvenile justice professional, the policies and procedures were discussed at length. There are an infinite number of situations in which you may be liable in your official capacity and suffer consequences. Later, we will talk about civil and criminal proceedings, but first, let's talk about some common laws which, if violated, could result in you being liable and subsequently sued in criminal court, civil court, or both. For juvenile justice professionals, some common laws which, if violated, could result in causes of action including detention hearings for status offenders and non-offenders. It is against the law for a JPO or JSO to knowingly detain or assist in detaining a juvenile non-offender being held for deportation in a secure detention or correctional facility, nor a juvenile being held for a status offense. A status offense is one in which there would be no arrest if an adult committed the same crime. Examples include truancy, curfew violations, and running away. We'll now discuss sexually transmitted infections or STIs, AIDS, and HIV testing, results disclosure. It is a crime to reveal or allow to become known information on test results or the STI, AIDS, and HIV status of a juvenile. The next cause of action is improper sexual activity with person in custody. JPOs and JSOs and other officials are prohibited from having sexual activity with persons in the custody of the Texas Juvenile Justice Department, or TJJD, in a juvenile facility or under the supervision of a probation department while not in custody. Now let's talk about tampering with a governmental record. If you knowingly make a false entry or alter records and either present it as a genuine governmental record or intentionally destroy, conceal, or remove a record, criminal consequences could occur. This also includes tampering with a warrant issued by a magistrate. The last cause of action we'll discuss is the violation of the civil rights of a person in custody, on supervision, or improper sexual activity. You, along with employees, officials, peace officers, or volunteers, committed offense if you deny the rights or privileges to a person in custody or engage in sexual activity with an individual in custody. Now we will discuss permitting or facilitating an escape. If you or an employee of a facility knowingly permits or facilitates the escape of a person in custody, you are subject to possible criminal consequences. Now we will discuss prohibited substances and items in a detention facility. If you provide or intend to provide a person in custody items such as alcohol, controlled substances, dangerous drugs, a deadly weapon, cell phone, or any wireless device, you may be liable. Failure to report. A JPO, JSO, or Community Activities Officer, or CAO, who has cause to believe a child's physical or mental health or welfare has been or may be adversely affected by abuse or neglect and fails to report could be sued. TJJD rules require juvenile justice professionals to report incidents of abuse, neglect, or exploitation, or A&E, within 24 hours. We've discussed the meaning of legal liability, how it can apply to anyone, and reviewed common causes of action that may lead to lawsuits. Now let's take a more in-depth look at the legal proceedings you may face if you fail to perform duties according to law and policy. For each duty not performed or illegal action, there are legal consequences or proceedings which may apply. There are 3 types of proceedings you may face if you fail to adhere to government laws and agency policies. These 3 proceedings are criminal, civil, and disciplinary. All litigation or legal action falls into either criminal and/or civil proceedings. Administrative proceedings may be initiated based on state or federal agency rules. Any one of these proceedings may occur when a person violates a legal duty, commits an act, or does not perform an act that should have been performed. Let's discuss each of these in more detail, starting with criminal proceedings. When someone breaks the law and is charged with a criminal offense, this means the person may be liable or responsible for the crime. These allegations lead to criminal proceedings which can occur on a federal, state, or local level. The parties involved in federal and state criminal proceedings may include a prosecutor representing the federal or state government and the defendant, the person charged with criminal behavior. Many of us are familiar with the phrase innocent until proven guilty. Proof is needed to determine whether the defendant actually committed the crime for which he or she is accused. There are two types of proof in legal proceedings. Burden of proof. This indicates who has to prove the allegations are true, and standard of proof, which indicates the level of proof needed to show the allegations are true. In criminal proceedings, the burden of proof is on the prosecutor, and the standard of proof is to prove beyond a reasonable doubt that a crime was committed and the defendant committed the crime. In other words, a prosecutor has to prove there is a 95% chance or greater the defendant committed the crime. The percentage is for illustrative purposes only, and no numbers are actually assigned to the levels of proof. The point is it takes a lot of evidence to convince a judge or jury beyond a reasonable doubt that the defendant is guilty of a crime. All juvenile justice professionals are expected to follow all laws while on duty. If a criminal offense is committed by an employee, the local investigative authority will conduct an investigation to determine whether the evidence, including physical items, pictures, documentation, and witness testimony, meets the elements of the crime as specified by law. If so, local rules will dictate the next steps. The legal consequences of criminal proceedings are largely the same regardless of whether the case is filed in a state or federal court. If a defendant is convicted by a judge or jury for a crime, he or she faces a full range of criminal penalties, including community service, a criminal record including sex offender registration, fines, restitution or fees, jail or prison, and probation. For example, an employee in a juvenile facility was convicted of official oppression for improper sexual contact with a male juvenile in custody and received 2 years of probation. Any of these criminal penalties will cause a life to change in an instant, and they are actually not the only consequences a criminal defendant may face. Before a trial even begins, public scrutiny in the media, whether through the news, television, or social media, may taint a defendant's reputation. Think about all of the pictures of the arrested juvenile officers we observed at the beginning of the training. Most of those correctional officers had only been arrested. They had not yet been found guilty of a crime, and still their pictures appeared in the media. The public may hold a guilty opinion of them before a trial even begins. Some additional consequences of criminal proceedings include financial, family, and/or employment hardships. Financial issues may arise from a defendant not being able to provide for his or her family if jail time must be served, or from legal probation or restitution fees assessed. Family issues may arise from lack of contact and loss of trust. Finally, employment hardships may arise due to a defendant's criminal status, which may lead to job loss or the inability to obtain a good-paying job. Let's turn our attention to civil proceedings. When someone fails to perform a duty he or she should do, or does something he or she should not do, that person is likely to face federal or state civil proceedings to resolve the matter. There are two parties involved in federal and state civil proceedings, including a plaintiff, the person or group suing, and a defendant, the person or group being sued. Remembering our earlier discussion on proof, civil proceedings may lay the burden of proof on the shoulders of the plaintiff and maintain a preponderance of evidence as a standard of proof. A preponderance of evidence is being able to present just enough evidence to make it more likely than not that what the plaintiff is claiming is true. This level of proof varies somewhat depending on the case and is a lower standard than what is required in a criminal proceeding. In other words, a plaintiff has to prove there is a greater than 50% chance the defendant breached his or her duty, resulting in harm to the plaintiff. Again, the percentage is for illustrative purposes only, and no numbers are actually assigned to the levels of proof. The point here is the burden of proof on a prosecutor in criminal proceedings is much higher than on a plaintiff in civil proceedings. A federal or state civil proceeding may be filed when there is an allegation a person committed an act or failed to act and the plaintiff can prove the defendant had a legal duty or obligation to fulfill, the defendant breached that duty, in other words, the act broke or failed to observe a law, agreement, or code of conduct. The defendant harmed the plaintiff as a result of the breach of duty, either purposefully or through negligence. The breach was the primary or proximate cause of the harm done, and the extent of the damages to be paid. A federal or state civil proceeding may occur whether the act was intentional, meaning it was done to deliberately cause harm, or out of negligence. Negligence in civil suits includes sins of omission, not doing something you should have done, and sins of commission, doing something you should not have done. For federal or state civil proceedings, negligence includes doing what a reasonably prudent or sensible person would not have done, failure to do which a reasonably prudent person would have done in like or similar circumstances, failure to exercise the degree of care that a reasonably prudent person would have exercised in like or similar circumstances. Negligence should not be confused with deliberate indifference, which is the conscious or reckless disregard of the consequences of one's acts or failures to act. For example, a supervision officer places two juveniles that fought with each other earlier in the day next to each other during a housing unit meeting. During the meeting, the two juveniles begin to fight again, resulting in one being seriously injured. The injured juvenile's parents sue because the supervision officer failed to separate the combative juveniles and did not report the earlier incident. The case is supported by evidence the incident occurred because the supervision officer ignored the strong likelihood the safety of the juveniles in the group would be at risk. The JSO may not be able to successfully defend against a claim of deliberate indifference because he or she failed to follow established policies and consciously disregarded the duty to take necessary precautions to protect the safety of each juvenile. When someone doesn't fulfill their duties and is sued, it means the defendant may be liable for the damages or harm done. In a civil proceeding, the defendant compensates the plaintiff for the damages or harm through monetary consequences. There are two types of damages, actual and punitive. Actual damages may consist of paying for things like medical bills and lost wages. The second type of damages is punitive. Punitive means penalizing or punishing. Punitive damages are designed to punish the individual defendant for his or her bad behavior. Punitive damages are often a severe monetary consequence against the individual who caused the wrong. Additional fees a defendant may be required to pay include court costs and attorney fees. Now let's take a moment to listen to a scenario. The following scenario is intended to allow you to apply what you have learned about civil proceedings to situations you could potentially face as a juvenile justice professional. Listen to this scenario, read the questions that follow, decide your answer, then compare it with the correct answer that is presented. A JPO lines up 5 juveniles to go to the back of the office for anger management class. A juvenile at the end of the line becomes rowdy, calls the JPO name, and slams him with the back of his elbow. The JPO throws a punch and breaks the juvenile's nose. We will now discuss the scenario answers. Number 1. What did the JPO do when the juvenile behaved inappropriately? He punched the juvenile. Number 2. What was the result of the JPO's behavior? His punch broke the juvenile's nose. Number 3. What was the JPO's legal duty in this situation, if any? As a juvenile justice professional, the JPO is entrusted with the care of the juvenile and should have ensured the juvenile's safety as required by law and followed the use of force policies, including de-escalation techniques as required by the department. Number 4. What legal action may be taken against the JPO? He may be sued in civil court and/or charged with a crime. Let's take a moment to talk about civil rights cases. When we think of civil proceedings at the federal level, civil rights cases are typically what comes to mind for most people. A civil rights case is a lawsuit brought to federal or state court alleging violation of a plaintiff's constitutional right or of a right given by federal or state law and seeks damages or the discontinuation of certain policies and practices. If a juvenile or their representative sues you in a civil rights case, he or she is most likely alleging you violated one or more of his or her constitutional rights. To be successful, federal civil rights proceedings must involve a violation of a constitutional right provided by federal law and an official who is acting under the color of law. Acting under the color of law is a federal concept that applies in both federal and state cases when a staff member presents himself as an employee conducting official duties. When you claim to be conducting official duties on behalf of a department, all actions you make are considered acts under the color of law. This is the case regardless of whether or not the action is within the limits of your authority. Almost everything juvenile justice professionals do with the juvenile falls under the color of law because of the nature of the relationship between them and juveniles. Juveniles on supervision regularly have contact with staff members, whether they are on court-ordered supervision or awaiting disposition. Now let's talk about some special circumstances that may happen in some cases. In some cases, there can be a bit of a twist. A cause of action resulting in both criminal and civil proceedings may leave you cleared in one and penalized in the other. In other words, when both criminal and civil liabilities are present, an individual may not be charged or found guilty of a crime in criminal court, but may be found liable in civil court. For instance, a defendant may be found not guilty of a crime in a criminal case and can be liable for breach of duty in a civil case, or vice versa. One example of this is O.J. Simpson's case from the 1990s. In 1995, a jury found O.J. Simpson not guilty of the murders of his ex-wife and a male friend of hers in criminal court. The prosecutors could not prove beyond a reasonable doubt that O.J. Simpson had committed the crime. In the civil trial, the families of the victims sued O.J. Simpson for damages. Through a preponderance of evidence, a jury unanimously held O.J. Simpson liable for damages and awarded the families $40 million. In this case, the prosecutor lacked evidence to prove the criminal charges beyond a reasonable doubt, but there was enough preponderance of evidence to pursue a civil lawsuit and win the case in that court. Remember, criminal proceedings have a higher standard of proof than civil proceedings. The consequences of either can bring nothing but hardship for anyone that violates the laws and policies. Criminal and civil proceedings are not the only legal actions employees may face. There are also administrative proceedings which may occur at the local level. Disciplinary proceedings may be initiated when an employee has failed to follow local policies and procedures or committed acts in violation of the law or other ethical violations. There are at least two parties involved in disciplinary proceedings at the local level, including the department, facility, or TJJD, the employee, or the person suspected of violating policy. In disciplinary proceedings, the burden of proof is on the local department, with the standard being a preponderance of evidence. The local investigating authority must prove the employee's behavior occurred as alleged and was a violation of department rules. When an allegation occurs against an employee at the local level, possible consequences include warning or reprimand, transfer or demotion, loss of JPO or JSO certification, termination or possible criminal indictment, possible conviction or jail time, and a criminal record. Every department will have certain procedures in place regarding investigations. It's important for you to be aware of those procedures in order to protect yourself. It's pertinent to remember if you are questioned, you are expected to fully, accurately, and promptly answer any and all work-related questions regarding an allegation. You are also expected to be truthful at all times and avoid making or submitting false or intentionally misleading verbal or written statements. The local investigative authority may also interview the victims or other juveniles with information regarding the allegation. Even if the victim does not cooperate, a solid case can still be built using corroboration or confirmation from other juveniles, coworkers, video, and documentation. Keep in mind, if other violations are discovered during the investigation, which were not originally reported, disciplinary action will occur for these as well. Typically, you are not able to appeal the findings of an investigation, but may appeal disciplinary actions. Again, it is important to be familiar with local procedures regarding investigations. TJJD recognizes most certified officers not only adhere to the highest standards of professionalism, but also take pride in the crucial role they play in working with juveniles. However, as we have learned today, There are some instances in which a JPO or JSO may risk losing the privilege of working as a certified officer in the field of juvenile justice. In accordance with Chapter 349 of the Texas Administrative Code, TJJD is required to take appropriate administrative steps to initiate discipline to a certified officer if TJJD discovers through a monitoring visit, compliance audit, or as a result of receiving notice in any other manner, an individual currently certified by TJJD does not meet the requirements in Chapter 344 of the Texas Administrative Code relating to the eligibility of certification. Or TJJD confirms a certified officer has committed a code of ethics violation. Or TJJD confirms abuse, neglect, or exploitation has occurred in a juvenile justice department, program, or facility. TJJD is also required to ensure every officer is provided due process prior to revocation or suspension of certification. TJJD's disciplinary process is conducted in addition to any resolution of a matter that either previously occurred or may be ongoing at the local level. Any action taken by TJJD is solely related to an individual's certification as a probation officer, supervision officer, or community activities officer. It is independent of actions taken by an employer or any criminal or civil suit which may arise out of the individual's conduct. In other words, one incident can result in a certified officer being disciplined at work, convicted of a crime, civilly sued, and having his or her certification suspended or revoked by TJJD. Typically, most juvenile justice professionals do not begin their employment intending to violate a juvenile's rights, disregard federal and state laws or agency policy, or engage in criminal activity. Actually, employees may not even be aware of the many consequences they may face if they do violate law or policy. Watch the following video titled Not Just One.
A local youth detention facility and an employee are being sued by the family of a resident who claims the employee asked her for sex. The case is already in the criminal court system and is now heading to civil court as well. Here's Harold Hayes.
38-year-old Derek Dawkins, a youth care employee, was charged last fall with making a sexual advance to a then 16-year-old girl who was a resident at Schumann Juvenile Detention Facility. According to the criminal complaint in that case, the girl worried that Dawkins would snitch on her for having lip gloss, which was considered contraband. Dawkins said he had to speak with her and returned with a note which read, "I like your young chocolate," and described a part of her anatomy. "If I give you my info, would you expletive with me? No disrespect."
The fact that this young man, who is an adult who clearly knew better, made, sexual advances to a juvenile, obviously says that there's some issues that are going on at Schumann Center that need to be addressed.
When the incident was first reported, Schumann issued a statement saying the case was reported to staff the day after it happened and that the information was promptly turned over to county police. But the lawsuit claims intentional infliction of emotional distress, negligence, negligent hiring and supervision, and vicarious liability, claiming the actions of Dawkins are the responsibility of Schumann.
You never place a child, who's already, under your authority, in the position of having to decide, how is the best way to address an adult who's making sexual advances towards them.
Dawkins was suspended without pay when charged. A spokesman for Allegheny County said the county does not comment on pending litigation. Meantime, Dawkins faces trial next month on charges including endangering the welfare of children and official oppression. From downtown, Harold Hayes, KDKA TV News.
Let's go over the questions and discuss the answers together. Number 1. How did the situation start? It started with lip gloss and a note. The juvenile didn't want to get in trouble for having lip gloss, which is considered contraband, and the juvenile worker returned with an inappropriate note after talking with her. While these may seem like insignificant items, they led to dire consequences. Number 2. Referring to the list of common liabilities, how did the juvenile worker fail to protect the juvenile? The juvenile worker did not protect her from abuse, neglect, and exploitation, or improper sexual activity with a person in custody, and violation of her civil rights. Number 3. What were some of the legal consequences mentioned? The legal consequences included the juvenile worker being charged criminally with endangering the welfare of children and official oppression for making a sexual advance of a juvenile. The juvenile worker being sued by the family for intentional infliction of emotional distress and negligence. The agency being sued as a result of the juvenile worker's actions for negligent hiring and supervision as well as vicarious liability. And the juvenile worker being suspended from his job without pay. Number 4. What might be some other legal consequences mentioned? Additional consequences may include jail or probation, a criminal record, financial burden, public scrutiny, a tainted reputation, and employment hardships. The juvenile worker didn't face just one consequence. He faced many for his inappropriate actions. To help you avoid undesirable consequences like those mentioned in the video, educate yourself on approved policy and procedure, think ahead about the decisions you may have to make, and consider the consequences. Decisions you make while supervising juveniles may have an immense rippling effect through your life, the life of your coworkers, and the life of a juvenile. By now, you may be wondering how to protect yourself from all of these potential legal problems. Let's discuss what protections are available to you. There are safeguards in place that may protect you from danger, being criminally charged or sued, financial hardships, or from losing your job, but only if you choose to abide by federal and state laws in addition to department policies and procedures. Juvenile justice professionals have 4 main areas of protection: good faith, scope of authority, qualified immunity, and representation. Good faith means acting with the honest belief that the action taken or the decision made was appropriate under the circumstances. If you act in good faith, you have no liability. Acting in good faith occurs when you follow standard operating procedures, the order of a superior within the realm of your duties or judge, advice of legal counsel, statute or case law, even if that law is later declared unconstitutional or the case is overturned. Bad faith is when an action is done with malice or there is an intent to harm someone. If you act in bad faith, you are liable. Scope of authority usually includes those duties noted in a job description and of the kind typically conducted by employees who hold the same position. In other words, an employee acts within the scope of his or her authority while discharging duties of the kind usually assigned to him or her. To be protected from legal proceedings, an employee must be sure they are acting within the scope of their authority. Let's listen to a few scenarios. Scenario 1. A JPO who is known to be an expert but unlicensed electrician notices some faulty electrical wiring in a juvenile probation office. The JPO notifies her supervisor of the situation and explains she knows how to correct the problem. The supervisor knows the JPO is not a licensed electrician but has heard great things about her level of work. The supervisor allows her to perform the work while on duty. A few hours after the JPO repairs the wiring, a fire breaks out. Scenario 2. A JSO who is known to be an expert but unlicensed electrician notices some faulty electrical wiring in a juvenile facility. The JSO notifies the supervisor of the situation and fills out the proper paperwork to order for maintenance. The JSO turns in the work order form per policy but notices sometime later the wiring still has not been repaired. A short time later, a fire breaks out. The acts described in the first scenario are not the kind generally assigned to a JPO. Both the officer and the supervisor would be operating outside the scope of their authority. JPOs must not do work other than what they've been trained to do for their particular job. In the first scenario, the JPO and the supervisor may both be liable for operating outside the scope of their authority. The acts described in the second scenario are the kind generally assigned to a JSO. The JSO was acting within his scope of authority by turning in the work order form to maintenance. In the second scenario, the JSO followed proper policy and would not be liable. As juvenile justice professionals, you also have qualified immunity. Qualified immunity is when you are not held personally liable if you reasonably believe your actions are lawful considering the given circumstances. For example, a JSO uses everything he or she knows from training and policy to initiate a physical restraint in a wet shower. The JSO slips during the restraint, causing both themselves and the juvenile to fall to the ground, injuring the juvenile. He or she may be protected by qualified immunity because even though the juvenile was hurt, the restraint was conducted according to policy and procedure. There may have been other alternatives the JSO could have used to avoid injury, such as using other de escalation techniques, but the totality of circumstances, such as the environmental conditions, housing unit culture, and the mood of the juveniles, are all taken into consideration during investigations. Juvenile justice professionals have qualified immunity when they operate with good faith, according to policy, and within the scope of their authority. The reasonable person and good faith standard also apply here. You cannot simply say you thought what you did was lawful. To claim qualified immunity as a defense in a lawsuit, you must have been acting with honest intentions and acting as a similarly trained juvenile justice professional would have given the circumstances. By statute, the Office of Attorney General, or AG, provides legal representation to county employees who follow policy, act within the scope of their authority, and with good faith. If the county does not provide legal representation on behalf of an employee, the AG must be notified. In these cases, the state will pay damages resulting from negligence and civil rights violations, but the law places certain limits on liability caps on the amount it will pay out. The state does not automatically cover punitive damages, as it is meant to be a punishment for the defendant, nor does it pay damages or represent employees whose inappropriate acts were willful, the result of serious negligence, made in bad faith, consciously indifferent, or a reckless disregard for the rights of another person. One significant way to protect yourself from legal proceedings is to document all of your activities while you're at work. This involves truthfully completing all paperwork on time. For example, if you report the abuse of a juvenile following all department policies and no one addresses the issue, your documentation of the dates, times, and people to which you reported the behavior may greatly assist in protecting you should a lawsuit be filed. You must also document any attempts to report suspect behavior of others. If you report a violation of law committed by another employee or the department itself to an appropriate law enforcement authority, you may be protected from retaliation or disciplinary action. Someone who has a reasonable basis to believe a law was violated and reports in good faith is often known as a whistleblower, as he or she is blowing the whistle on the violations committed by a department or an employee. Other protections you must use to shield yourself from legal proceedings include following all department rules, regulations, and state statutes, asking a supervisor or seeking legal advice when in doubt, being aware of changes in the law and TJJD standards, participating in all mandatory trainings, participating in additional trainings when possible to enhance professional development, reporting all observed violations to appropriate supervisors or authorities, avoiding inappropriate conversations with juveniles, no off-duty contact with juveniles on supervision, refraining from accepting or giving personal gifts or correspondence, using restraints in the proper way, remaining professional at all times. If you follow these suggestions and keep in mind the training you have received, your exposure to liabilities and lawsuits may be greatly reduced. Just remember to weigh your choices and their consequences as you perform your job duties. As juvenile justice professionals, remember, you are personally and legally responsible for your decisions. Avoid unnecessary situations by being aware of common liabilities juvenile justice professionals often face, and be mindful of the various protections available to you. As a reminder, the material covered today is for informational purposes only and must not be considered legal advice. Contact your supervisor, local county prosecutor, or a private attorney for questions about specific legal matters. For technical assistance and resource information, contact the Texas Juvenile Justice Department's Legal Help Desk at 512-490-7121. Thank you for participating in the Understanding Professional Liability course today.